Good morning and welcome to this meeting of the Licensing Subcommittee. The first item on this morning's agenda is the election of chair. Do I have a proposal from the floor, please?
I'm happy to propose Councillor Flagg.
Thank you. Councillor Harman? You happy, Councillor Howe?
Yeah.
Thank you. Item 2 on this morning's agenda is apologies. But before we move to apologies, can I just ask the clerk to run us through the housekeeping measures for this morning's meeting, please?
Thank you, Chair. Please note that this meeting of the Licensing Subcommittee is being recorded by the Council for live broadcast and will be published on the Council website for a minimum of 6 months. For those in the room, please note that if the fire alarm sounds, please exit the building by way of the nearest available signed fire exit route and make your way to the assembly point at the War Memorial in the gardens opposite the front of this building in Bourne Avenue. Finally, if joining remotely, which doesn't apply today, but also for everyone in the room, can we ensure background noise is kept to a minimum and that mobile phones and other devices are switched off and laptops are turned to silent for the duration of the meeting? Thank you.
Thank you. Can you confirm if we have received any apologies as of this morning's?
None received.
No, thank you. Declarations of interest. Do members have any declarations of interest regarding the items that are on this morning's agenda? Councillor Harman?
No, none.
Councillor Howe?
No.
And the protocol for public speaking, a protocol for public speaking at formal in-person meetings of the Licensing Subcommittee is included within the agenda sheet for this morning's meeting. Item 5, Havana, 61 Chalmster Road, Bournemouth, a request to adjourn the review of the premises licence. The Licensing Authority has received an application from Dorset Police to review the premises licence for the premises known as Havana, 61 Chalmster Road, Bournemouth, BH8 8UE. The subcommittee is asked to adjourn the hearing until the 26th of November 2024 to enable the premises to be legally represented at the hearing. This is in accordance with Regulation 12 of the Licensing Act 2003, Hearings Regulations 2005, and is with the agreement of all parties. Do all members agree to adjourn the application to the 26th of November? Councillor Harman?
Yeah, I'm happy with that.
Thank you. Councillor Howe?
Yes.
Thank you. Good morning, everyone. Item 6 on this morning's agenda, simplypleasure.com, 333-335 Holderness Road, Bournemouth, BH8 8BT. ABS Holdings have applied for the renewal of the sex establishment licence to permit the premises known as simplypleasure.com, 333-335 Holderness Road, Bournemouth, BH8 8BT, to trade as a sex shop for a further 12-month period. The Licensing Authority has received 3 objections and 2 letters in support. This matter is brought before the Licensing Subcommittee for determination. I will now ask each participant to introduce themselves and state their role. I am Councillor Flagg, Chair for this morning's subcommittee meeting.
I'm Councillor Emily Harmon. I'm a ward councillor for Parkstone and a member of the Licensing Committee.
I'm Councillor Mark Howell. I'm a ward councillor for Poole Town and a member of the Licensing Committee Sub-Committee.
Thank you, members. We also have joining this morning Councillor Paul Hilliard, who is a reserve member. However, he's not required to participate, but remains to observe for training purposes.
Good morning, Sarah Rogers, Principal Licensing Officer.
Good morning, I'm Michelle Cutler. I'm clerk to the Licensing Subcommittee today.
Good morning, I'm Joanne McNamara, Legal Advisor to the Subcommittee today.
Good morning, Okay.
Don't pick up, don't worry.
Good morning, I'm Susan Stockwell and I am one of the objectors, I think referred to as #1 in the papers.
Thank you.
Good morning, my name is Tom Clark and I'm the National Retail Manager for Simply Pleasure.
Could I just remember to turn you?
Sorry.
Well spotted. Before I run through the procedure, please may I check that all persons who have given notice of their intention to speak have been identified, and any person who wishes to withdraw representation or wishes not to speak has been identified. If there are no comments, I will take this as correct. I will now explain the proposed procedure and order of speaking for the hearing as follows. The licensing officer presents the report. Questions of the licensing officer by all parties, members of the subcommittee, to go first. The applicant will make their application. Questions of the applicant by all parties, members of the subcommittee, to go first. Objector will make their representations. Questions of the objector, members of the subcommittee, to go first. All parties will be given an opportunity to sum up, with the party who spoke last to go first. The hearing will then conclude. The subcommittee will deliberate in private with the legal advisor and clerk present. Where possible, notification of the subcommittee's decision will be given within the period of 5 working days, beginning with the day or the last day on which the hearing was held. The notification of decision will include information about the right of appeal as appropriate. I will now ask all parties to firm agreement on the proposed procedure or make representation. Thank you. Finally, please may I remind all parties speaking not to repeat the information which has already been given in writing, but to expand on their written representations. All questions are to be asked through the chair and there will be no cross-examination of parties. I will now ask the licensing officer to present the report. Sarah.
Thank you. Application is made by ABS Holdings for the renewal of the sex establishment licence for a further 12-month period. The premises have been operating as a sex shop for the past 22 years under the current ownership, and the licence permits them to sell products, magazines, films, clothing, and equipment connected with sexual activity. The application made complies with the relevant legislation, and the necessary site and newspaper notices were published in accordance with that. As a result, 3 objections have been received. Objector number 3 refers to some letters which were not accepted. For full disclosure and transparency, these letters have been circulated and the correspondence between myself and them and has been attached to my report. 2 letters in support of the application have also been received and included within Appendix 4. No objections were received from Dorset Police, the Fire Service, Environmental Health, Trading Standards, or any of the responsible authorities who are identified under the Licensing Act who were also consulted. Any decision to refuse this renewal application must be relevant to the mandatory or discretionary grounds as set out in my report. Section 8 of the Act allows the authority to renew a licence on such terms and conditions and subject to any restrictions as may be specified. Thank you.
Thank you, Sarah. Do members have any questions for the licensing officer at all? Thank you. Can I then call upon the applicant to address the committee, please? Right, I've just been reminded that this morning we received further questions from objector number 3, and it's basically just to make you aware, and I will be asking those questions of the officer when we get to that point. But I can assure you that the members only received this morning as well. So, okay, Tom.
Thank you. So I'm here in support of the renewal, and I'd just like to make a few very brief statements of facts describing our operation on Holdenhurst Road. We always work in accordance with the licensing conditions. There have been no objections, as Sarah has stated, by the police, the fire officer, or any other body that may be interested in our licence renewal. The council have received 2 letters of support for the licence renewal. We're a local company. We employ a local team of a store manager and sales assistants, all of whom are female. Any external changes to the shop are proposed and approved by the council before any changes made to the store. Our store window displays use fully dressed mannequins in lingerie and underwear. This is nothing different from what you might see in a high street store or at Castle Point, in M&S, or in the window of Next, for example. The front of the store has an automatic close mechanism, and stock cannot be seen from that door when it's in operation. There's been no changes to the local area since the last renewal, with the exception of our decision to close the store at 180 Holdenhurst Road. So our store at 333 to 335 is now the only adult store on the street. Our store is professionally run as part of a 19-store chain operating throughout the UK. The store is a safe place for all people, but especially those who are part of the LGBTQ+ community. Our customers receive excellent service from a highly trained team, and our team also follow the Challenge 25 guidelines to ensure that people only 18 and above are permitted entry. We've never had a licence refused or failed to be renewed. We are a responsible organisation who take the licensing process seriously. So I'm here today to be able to take questions and further explain our operation in support of the licence renewal.
Thank you very much, Tom. Members, do you have any questions at all? Councillor Harman.
Thank you. Can I get some clarity if that's okay? So looking at the unit, it sort of appears to be 2 separate shops. And it could be that this has changed since I last checked, but Prowler on the left and then Simply Pleasure on the right. This is one business, just to clarify, but it looks as if it were 2 sort of sets of branding.
Yeah, so Prowler is a brand that we own that is displayed on the store front, but the store trades as Simply Pleasure. There is one entrance to the store at the front of the store, and it is branded as Simply Pleasure. But Prowler is one of the brands that we own. It's well known in the gay community, and so this is one of the brands that we promote in the front of the store.
Thank you. And just to clarify as well, because on the right-hand side, the sort of the banner, the name of the store, Simply Pleasure, but it says simplypleasure.com, doesn't it? So it's got the internet address on there. Great, okay. And my next question I wanted to ask is about the window display. So am I right in thinking that that comes before the licensing department, that the officers have to okay what's put in the window?
No, any significant changes to the front of store. So we recently updated the front vinyls that cover the store, and that was proposed to the committee and to the licensing officer and approved before those changes were made. So it's any significant change to the front of the store, whereas the store window is changed as long as we're working within the licensing conditions. There would be nothing that would be reasonably classed as obscene in the window, and so this is why we have lingerie displays and fully dressed mannequins.
Just on that point, again, sort of looking at the Google images, and this is from, I think, July last year, and I do appreciate you say other high street chains do have lingerie and things in the windows. It does look slightly different. The images I'm looking at is sort of nipple covers and things like that than you would see in somewhere that's a more high street store. And I just sort of want to check what checks are in place. So from between yourselves, the business, and also the licensing department. So when a new display is put together, I just want to check that does get checked, that it is appropriate and within the guidance and the guidelines that have been set. So just could you talk me through what that process looks like?
So that's our responsibility, to make reasonable changes to the window to display items that arguably couldn't be classed as something obscene, that would be reasonable to be seen on other high street retailers selling lingerie as we do. There is no submission to the council for a change of window dressing. If any objections were to come through by members of the public, then the licensing officer would be in touch to understand what the window is actually displaying, and then a discussion may be had from that point if they wish to discuss it with us. But the window changes, as I understand it, are not classed as a significant change to the front of store, and so we change them with what we think is reasonable, which would be fully dressed mannequins.
Just a final question from me, if that's all right. Am I right in thinking there's one access point to the store? So when you accept deliveries, they have to go through that front door. I know you mentioned that it closes automatically, so sort of it can't be left open, and then the product's inside displayed. I just want to understand how you manage the delivery process. I used to work in a retail shop many moons ago, and when deliveries come in, you do need that access point open and free for quite some time when you get that stock in. How do you manage that so that's appropriate?
Yeah, so the front of store is our main door. There is a fire door as well, but that's not used for deliveries. So we, take one box at a time. The delivery driver comes in with one box. The door opens as he opens it and automatically closes, just like it would do when a customer walks into the store. So the door isn't blocked open. There's not huge amounts of stock where it would need it to be blocked open. So the automatic door system operates just as it would do with somebody walking into the store with a bag, for example.
Thank you. Any questions, Councillor Howe?
Yeah, I'm a little bit surprised, having driven past the store this morning, that the vinyls that are there at the moment are, to me, that looking at the previous pictures, they look like have blind arrangements rather than vinyls, or certainly what the over effect now is to be much more in your face, because it looks very different from another, other shops. It looks like, you shouldn't look here and therefore you do.
Yeah,
but if that
has
has been approved by another subcommittee, then that's irrelevant, I guess. So, but in terms of the how you dress the windows, do you have a policy for how you dress the windows? And if you do not, how do you determine what should and shouldn't be in the windows?
Sure. So our policy is not to put in anything. So, for example, bondage accessories, whips, crops, that type of thing. We would only use fully dressed lingerie mannequins that are fully covered, with no, no kind of bondage accessories, things like that, which other stores may use, which aren't licensed. But we choose not to put those in, and just have fully dressed lingerie mannequins with perhaps a theme, for example, Halloween theme. Or a summer theme, just like any other retailer would dress their windows in that kind of theme. We'll go ahead into Christmas and have a Christmas theme in the window, and again with fully dressed mannequins displaying lingerie that we sell.
Okay, so what exactly do you mean by fully dressed?
So there isn't nipples covered. There isn't, for example, crotchless underwear being worn, that type of thing.
Okay, so not quite fully dressed in the council sense. Okay. Thank you.
Yes, if you would, please.
just following on from some of the questions that have been asked, I wonder if the licensing officer could just clarify. So the signage, am I right in thinking the signage and the posters, they have to go to licensing to approve? Is that correct?
Yes, and
Okay.
the window displays so the day-to-day change of the window display doesn't, but permanent window displays, for example, the recently been approved, the rainbow colour, hasn't it? For the Prowler, the new vinyl on there, that came to myself and got approval from the vice chair.
And if you had complaints about the mannequins,
No.
and if you did, you would investigate
Yes,
that.
we would go and have a look at them.
Okay,
Yeah.
thank you, just so that I'm clear that there's difference between the mannequins and the advertising poster element. Thank you.
Thank you for that. I just have a question, Tom. In the report, the company is identified as being simplypleasure.com. Can you confirm if that is registered with Companies House, or is it a trading name of a holding company?
Yeah, so Simply Pleasure is our legal name, and we own all the trademarks and the websites and everything to do with Simply Pleasure. Our parent company, which is ABS Holdings, was obviously referenced by Sarah, and that's our parent company, which is also a wholesaler and everything else. And Simply Pleasure is our legal identity and what we trade most of our stores under.
Okay, so just to clarify, it's Simply Pleasure, not simplypleasure.com.
So simplypleasure.com is what the store is named, and then Simply Pleasure is our legal identity.
Thank you for that. Are there any further questions for Tom at all? In which case, sorry, Councillor Howe.
Yeah, when you say Simply Pleasure is your legal identity, I think probably what you mean is a trading name, because Simply Pleasure, the legal identity is the Simply Pleasure Limited, I think, isn't it?
Yes, correct. Yeah.
Yeah.
Thank you. Susan, did you have any questions at all for Tom?
Yes, I do, Chair, and I'm very mindful that it's through you, so I'm going to not look at Tom, if that's okay. I wonder if the applicant would be surprised to hear that the copy of the licence that I have before me, which is printed off from the public pack, on page 29 at point 30, uses the word any. So no window shall contain any sign, advertising material, goods or display without the written consent of the council. Now, I wonder, Chair, if the applicant has a different version of this licence in front of him that doesn't have the word any, because he seems to have inserted the word significant.
Can I refer to the legal officer to clarify that, please?
So I think Ms Stockwell's referring to clause 30 on page 29.
Yeah,
is that right?
yes.
It says
Thank
no
you.
window should contain any sign, advertising material, goods or display without the written consent of the council. That's what you're referring to, is it, Mrs Stockwell?
It is, yes,
Yes,
because it's been said that any significant change in the window must be approved, which would be covered by this, but it is any goods displayed.
I suppose that it's a statement that you're making rather than a question.
Well, it's a question as to whether the applicant is surprised to hear that I have that in front of me. Perhaps he has something different.
No, I work from the same licence as you do.
Mm-hmm. In addition, the applicant is, I think, national manager, is that right? Now, would he be surprised to hear that I have seen with the underwear in the window, harness type material, only a little in fairness, which looks like black leather with kind of rings of metal. interspersed, not all the time, but occasionally in that display. Now, personally, I would consider the wearing of even a small amount of harness equipment to be associated with bondage. So I wonder if he could answer whether he is aware that those have been displayed in the window.
Yeah, without seeing the product, I wouldn't be able to comment.
I see.
I don't know which item you're talking about, so it'd be difficult for me to.
That's something to be worn sort of in this sort of area, I suppose.
What, like a bra?
No, it's for a man.
Okay.
I think they've slipped something into the window, possibly without it really going through the process.
Yeah,
But then nothing at the
seeing it, I wouldn't
moment.
know.
No, nothing on the bondage line just at the moment. Also, I'm quite experienced at my age of going into shops to buy underwear and of watching displays of underwear, and having worked in a department store, as you've heard, Chair, which is actually one of them right next to the underwear department. And I have to say that it surprises me that the applicant is saying that that the underwear displayed is no different from that which you would see in other shops. And I'm very loath to tell him why I think it's different, but because the cameras are rolling, obviously, and I certainly don't want to be viral talking about women's breasts, but I am going to. So my question is, are you aware, or would you be surprised to hear that I have never seen underwear displayed in windows other than in sex shops such as your own, which emphasises the nipple area and in fact is designed to entirely expose the nipple and the area of about maybe 4 inches in circumference around the breast. I've not seen that since the 70s, when it was quite fashionable to have a cutaway bra that you would then put a dress over. It's just fashion vary. Would you be surprised to hear that I've never seen that despite all my years of walking down high streets, except in sex shops?
I can't really comment on what you have or have not seen. A bit of a difficult question, that one.
Yes, I should say that they wouldn't, were you expecting them to perhaps be useful for breastfeeding because it exposes? Because in that case, you have a flap, which you then keep any sort of something for milk leakage in. I mean, I've certainly seen bras that have a cutaway elsewhere, but they were for feeding babies. I can stop now. Yes, I think I probably have overextended myself.
Can you limit your
yes
to questions rather than
statements? Yeah, the question is, are you absolutely sure that this type of article with this area of the breast entirely exposed is available in other shop windows than sex shops?
Am I entirely sure that I've seen the exact same products that we sell in other stores? Yes. Yes.
Thank you for that. Right. Moving on then, Susan, would you like to address the committee with regards to your objections, please?
Thank you, Chair. And I've just got a couple of points that have arisen since I submitted. I mean, as you've seen from my objection, it's quite comprehensive in case I can't make it one day. So there are a couple of points. One is just to remind you, and hopefully without repeating myself of what's in here, that buried in all those pages is something relevant to the other objections about people attracted into the neighbourhood, potentially attracted into the neighbourhood, and I have quoted the case law on that, so I'll just move on from that. Also to point out that I still, let me just think this straight. I have actually seen the statement, the very late statement that's come in this morning, and that refers to the Rotherham sexual establishment licensing policy. By the looks of it, just reading between the lines, I've only seen it this morning. That reminds me that I take the view that we do have an active policy at the moment, but that is in my objection. Also, since I submitted this, I can withdraw the part about unsuitability of the building because I'm happy to have seen the plan of the building. I was concerned about the suitability of the premises, which is a valid ground for objecting, but I have seen the plan now, so I'd just like to be clear that that part's withdrawn. Also, since whilst looking through the website for something which I didn't find, I was very pleased not to find, I did see the dog models, which I really think point to unsuitability for licensing, as in point to the unsuitability of the applicant for being licensed to run a sex shop. The dogs are wearing gags and or masks and or chains, not as a sort of chain that you control a dog with normally, but on the ankles. I don't know what they're called in a dog, but
They're not real dogs, they're soft toys.
No. They're highly stylized, definitely. They don't look like a real dog, but they are dog sized and they're weighted.
They're soft toys with accessories on them. They're not.
Tom,
Sorry.
can I ask you not to interject, please? Thank you.
Yeah, I can't really see from where the chains go, but they're like each of the feet on one of them, and on the other, I think there are smaller ones as well. I found it quite disturbing that they had ropes on as well, and I think they were called Roped Up Rover, and they came up when I was searching the bondage equipment. And I have to say that what I was looking for in the bondage equipment wasn't there, so I was very pleased to see that, but I wasn't very pleased to see that. I also came across, when I was looking to see if the dogs had been removed, some models, and I can't quite remember whether they were on the ABS site, or which is a wholesaler one, I think I'm right in thinking, or the Simply Pleasure one. And what really struck me about them, I mean, there's nothing particularly unusual about them. I'm fairly familiar with, paraphernalia sold by sex shops, was they were model women down to about here, so covering the chest and the head. But what really struck me about them was the expressions on their faces. They were designed to be very realistic. One, I would say, had an expression of reluctance or shyness, another of disdain, and I can't quite remember how I described the third one, but it was sort of along the lines of the disdain. Now, in the light of your public sexual equality duty to improve relations between the sexes, I would say that those products, using a sex article which has the heads of women with these very inappropriate, they just didn't look right. They didn't look happy, excited. They didn't look as if they were experiencing any form of pleasure. The models, they looked as if they were being used by someone who wanted to be almost attacking a woman by using these articles, because they didn't have friendly, positive, excited, any expressions that I'd consider as something if you're wanting to improve relations between the sexes. So that's that bit. On the support letters, now, it only occurred to me, so I've only notified your officers very, very recently, because it just hadn't jumped into my head. In a 2003 for our Licensing Act application, then the public send in representations, and they can be against or for. So you're used to seeing letters of support in those applications. However, I cannot see anywhere in the legislation for sex establishment licensing anything other than the right to file an objection. Now, the reason I raise this is because if you consider items of law, policy, evidence which are not legally relevant, then you're leaving yourselves in difficulties as far as some form of judicial review. I can't afford a judicial review. I'm not going to be doing it, but I'm just making the point that basically a letter of support is not something which the legislation setting up the licensing regime covers as being something that can be accepted. If there's something else that allows it to be accepted, all well and good, but it's just not the same as a Licensing Act 2003 application.
Can I just stop you there?
Yes. And
Sarah?
that's everything, actually.
Okay. All I was going to do is ask our legal advisor with regards to the point that you've just made.
Mrs. Stockwell raised this point yesterday, and myself and the licensing officer had a discussion. And my view is that although the Act doesn't specifically refer to letters of support or evidence of support, it's all part of the application. And as a licensing subcommittee, you can consider them as you see fit and attach what weight you see fit to place on them.
Thank you for that, Joanne. Members, do you have any questions at all for Susan? Emily.
Thank you, Chair. Just a point of clarity, if that's okay, Susan. So you were raising the suitability of the applicant, and I just want to clarify that I was understanding correctly on the grounds there that you were referring to various images you've seen. That was online, wasn't it? That wasn't anything you've seen physically in the store.
The items that I mention just now, as in the head and chest, I've only seen online, yes, and the dogs I've only seen online as well, yes.
And just to check, so that was, is that through, obviously we've got the simplypleasure.com that's advertised on the shop front. Is it through following that you saw these images, or I just want clarity on how you found those images?
The dogs I've seen on both simplypleasure.com, which is what I checked initially. And then I'm pretty sure that when I was looking at ABS Holdings, because that's the wholesaler, checking whether the dogs were still on there or if they're still on there, that was when I came across the head and chest models.
Thank you. And again, just a point of clarity. So these were images you saw that were advertising products for sale?
That was my understanding, yes. Yes.
Thank you.
Yeah, this is more a question for our legal support, which is, I mean, we're here to look at an application for a sex shop in Bournemouth. You know, what relevance, if any, can we put on a website trading business, or the potential for other, you know, some evidence that other branches elsewhere out of our jurisdiction, you know, possibly behave and addressed in a different way from the premises that we're dealing with.
My view is in relation to items online, they're not covered by the licence for these premises. So does that answer that question?
Yes.
Yeah. And in relation to, it's a question in relation to this applicant operating shops elsewhere. I do think that's something you can take into account, but I'm not sure what evidence you've heard to suggest there's an issue.
So yeah, I mean, I get Susan's point, which was I was a little bit confused. I think Emily tried to clarify it, was whether the kind of bras with the flaps that you're referring to were actually in a window of another shop, or whether you just saw them online.
I've seen plenty. I think I've actually even been involved in selling bras with flaps, because you have a flap that comes down for feeding the baby. But can I just come onto this business of what's bought through the website and what's on the shop that you were raising?
Well, I'd like first if you were to just answer whether you'd actually seen the you know, the bra that of concern to you actually in another shop window of the branch of Simply Pleasure.
Well, Strictly speaking, I haven't seen the windows of any other branches of Strictly Pleasure. I tend to go via the Google Street View, but I can't remember exactly what I've seen in the other shop windows in Google
Okay,
Street View.
thank you.
I was.
You started to, yes, sorry. You started to talk about the website. I think it's not my, I think to me that sounds like a bit of a legal question that I'm not qualified to address. But
I had looked at the websites, assuming, possibly wrongly, that there was the usual arrangement of click and collect, that something sold on a website you could go and pick up from the shop. However, the applicant's better placed to answer this than I. When I had a look at the websites, I couldn't see that there was a click and collect facility. So it may well be that those products that I was looking at on the website advertised aren't actually sold in that shop at all.
Any further questions?
But it's for the applicant, but is that okay? But based
Well,
on...
I think what we'll do is ask Tom if he first of all has any questions for the objector, for Susan at all.
No, thank you.
Thank you. We have another question from Councillor Harman.
Sorry, it's based on the content of the objection, if that's okay. So it's just on the back of that. Included in the objection was an article about a skimpy schoolgirl outfit. And I just wondered what measures, if any, hopefully the business have taken to adapt to ensure that the displays within the window are appropriate and not taking in mind things that have been raised as potential issues, if you're aware of that and you have sort of reacted to it, if that makes sense.
Well, we need to be aware of what other non-licensed retailers do. You will see outfits like schoolgirl outfits in the fancy dress stores, in supermarkets around Halloween. We currently, I don't believe, have anything in the window, but if it's fine for unlicensed stores, I don't see any problem why we shouldn't also advertise it in the window.
Right. At this point, I would just like to put the points which are raised by objector number 3. I won't read through either 2 or 3 in full, but just the questions that have been asked. Question number 1, what is the number considered to be appropriate for that locality, and how has this been decided? This is in relation to the number of sex establishments in a locality. Question, did you want to answer that? Or
I think it's for the licensing officer.
Yes.
Thank you, sir.
We do not have a policy which dictates how many licensed premises we have in our locality, so there is no number.
Thank you. Question number 2. BCP Children's Services have had requests to give a view on safeguarding and potential for harm and risk to children or vulnerable adults arising out of the location of sexual entertainment venues and sex shops, including from myself and another councillor, but have failed to respond. As councillors, we have responsibilities as corporate parents. I find this extremely concerning and would like to know why Children's Services have not given a view. Are you able to answer that one, Sarah?
I can, yes. They don't have to give a view. So as I said in my introduction, I consult with all those responsible authorities who are recognised under the Licensing Act, which does include child protection. For all other applications, I do that as a matter of courtesy and so that they're aware of other applications coming in through the licensing team. If they have no objection or have no comment to make, they don't. So then they don't have to respond to us. And if they wanted to make an objection, they could. So that would equate to them not having any concerns as far as I'm aware.
Thank you. And finally, question 3. There was an adult shop located at the other end of Holderness Road for many years, located literally on the doorstep to the red light area. The windows were black and the signage simply said adult shop. Why is the Simply Pleasure adult shop located further up Holderness Road treated differently? Why is that shop no longer there?
So the shop referred to was another Simply Pleasure shop, and it wasn't treated any differently. It was just styled differently, and it closed, as Tom said earlier, in October 23.
Thank you for clarification on that, Sarah. Right, we're looking now at summing up. So can I call upon Susan Stockwell to sum up your objection regarding anything you may have overlooked or missed in your presentation? Right, I've been asked to clarify that members have read the information that's been supplied to us by the objectors in full.
I can confirm I have.
I have not read what we received this morning, so I will need to do that before we make a decision.
So,
Sorry, Chair, can I just clarify that question's in relation to the information in the report, not the information provided 15 minutes before the hearing, that members haven't considered that new information. That makes sense?
Yeah, no, I didn't give it.
No. So
Yeah.
the documents that we're asking you to confirm you read are those in the report that's been published?
Yes, I can confirm that.
Thank you. Just to clarify. Thank you.
yeah, thank you for that.
Thank you.
Susan, please.
Thank you, Chair. There's only one thing that I've overlooked asking, and that was, you've seen in my objection, I'm sure, that I believe that the Bournemouth policy applies at the moment, and it does exist. And I'm just wondering if anyone can help me with how it's believed that the quashing order for BCP's sex establishment licensing policy distinguishes itself from the usual arrangement that you go back to the position immediately before the decision to adopt the BCP policy was made. I mean, do you want me to? I mean, I'm trying very hard not to repeat what's in my objection, but basically, why aren't you doing?
I'll ask our legal.
Yes, it's really why aren't we following the normal law of the land on this?
I have to be careful because what I advise the subcommittee is legal privilege. What I can say is that we have sought external legal advice on that point, and the point is that decision on that judicial review and the process that the council had taken to get to the decision to consider a BCP policy, all those steps meant that the Bournemouth policy stopped and wasn't revived. So there is no, our legal advice is there is no, the judicial review on the BCP policy didn't revive the Bournemouth policy. So there is no policy. That's where we're at.
Well, you can. I mean, members can see what's in my objection, and that is, you know, I've quoted what the judgment said.
Thank you for that. Tom, is there anything else you'd like to bring to the committee's attention at all in summing up?
No, thank you.
Thanks very much. Right, I will now conclude the hearing. The subcommittee will deliberate in private with the legal advisor and clerk present. Where possible, notification of the subcommittee's decision will be given within the period of 5 working days, beginning with the day or the last day on which the hearing was held. The notification of decision will include information about the right of appeal as appropriate. I will now ask all parties to confirm agreement on the proposed procedure or make representation of repeated myself there. Sorry. Everyone happy? Okay, thanks very much. You may leave.
No, that's just very good to have an assistant.
Item 7 on this morning's agenda, exclusion of the press and public. In relation to the items of business appearing below, the committee is asked to consider the following resolution: that under section 100A4 of the Local Government Act 1972, the public be excluded from the meeting for the following items of business on the grounds that they involve the likely disclosure of exempt information as defined in paragraphs 1 and 2 in Part 1 of Schedule 12A of the Act, and that the public interest in withholding the information outweighs such interest in disclosing the information. Are members happy?
Yes.
Yeah.
Thank you. Could you end the live stream, please, Clark?